2015 to 2019, non-bailable warrants were issued to the accused, proclamation and attachment. The accused did not appear. One line from the PW1's evidence. You are a tea stall owner, right? Accused of a tea stall owner. I saw a movie where the one person, Peraten, I further received information that after submission of the charges, the accused, avoiding trial, changing his place of abode, sometimes stay in a temple as priest. Interestingly, ultimately, after 4 years, investigating agency got the information that accused Nilakanto by changing his name from Nilakanto to Nilkamal is staying at Kamakhya temple as a priest. He became sannyasi, priest in Kamakhya. From there, from Kamakhya, you were arrested. So absconding for 4 years itself is also a circumstance. Ultimately, on October 2019, from Kamakhya as a priest, as Nilkamal, from Nilkanto. So Baba Nilkamal. কি হয়ে যায় ক্রস নয় না নতুন ক্রস করতে বলতে আলটিমেটলি মানে এডমিট করে পারাই নাই তাক মানে ব্ৰেকে কৰিব পৰা নাই ক্ৰছ এক্সামিনেশ্যন একদম বাবা এই হস্পিটেল শ্লো গাইছে মুখস্থ কৰি পেলালে মৰিছে কি ষ্টৰি So you are Nilkanto Nath or Baba Nilkamal? From the record of the accused Nilkanta, by changing his name from Nilkanto to Nilkamal, he is staying in Kamakhya temple as a priest, and record reveals that accused defaulted. Right. Mhm. So you know the story of your client. After the Sarsit,
Mine.
he did a vanishing act.
Mine.
For 4 years, non-bailable warrant of arrest kept on issued,
Mine.
proclamation and attachment. You were tea stall owner at that time when the alleged commission of the offense.
Mine.
But by 2019, from 2015 to 2019, you avoided the trial,
Mine.
right?
That is a circumstance.
Then you became a Baba in Kamakhya temple. You became a priest.
Mine.
You changed your name.
Hmm.
Right?
Mine.
Ultimately, from Kamakhya temple,
He was a player.
you were arrested after 4 years.
Mine.
You delayed the trial.
Mine.
This is the story.
Mine.
Post
Post.
Sarsit.
Mine. Conduct is not visible. Whatever I have done.
That itself
Mine.
is a adverse circumstance
Mine.
against you.
Mine. Can I pray for my with all respect, my day after tomorrow, my because
পাহৰি যাম আৰু মই চাব গৈছো ই এটা প্লি লৈছে মানে ইনজুৰি বুলি সেইকাৰণে চাব গৈছো সেইটোৱে চাই আছো মই ৰেকৰ্ডত সেইটোৱে চাই আছো কিবা আছে নেকি এটা যে সি ক'লে যে মাৰপিট লাগিছে বুলি সেইটো কাৰণে Needs 72 years. Yeah, the conviction. If you run in a building, you got free. You don't have anything. Okay. Law control not. Date of offense to get here? 10/7, no? Hello. You were arrested 10/7. The commission on the offense was on 10/7.
10/7.
You took a plea in 313. That is why I was looking into it. But you got arrested only in 27.
Mine.
After 10 days, meaning never you left the place of occurrence. And you were arrested from someplace else.
Mine.
You were not in your house.
Possibly.
So that plea that I was injured, that defense plea,
Mine.
You can make submission on it, but just
Mine.
to shorten the matter that you were arrested after 10 days.
Mine.
Then you took a defense plea by way of suggestion,
No.
say there was a scuffle,
Mine.
right?
Mine.
And you got injured. Accidentally,
No.
the accused got injured.
Mine.
And I got also injured.
Mine.
But there is nothing. You left the place.
Mine.
And after 10 days, you were arrested from some place
Other
else, right?
Right.
That 313, I was injured. There is no evidence. After 10 days, you appeared. You were arrested,
Mine.
right? And then you made a prayer for, submitted a petition for providing treatment. Providing treatment is other ailments, not for injuries.
Mine.
Other medical ailments because you were aged person.
Mine.
So that injury was not there.
Right.
Prima facie.
Right.
From records, it is not emerging.
Mine.
So that 313 and coupled with the defense plea perhaps may not be available to you
Mine.
because there is nothing on record. Had you been arrested
Mine.
on the date of occurrence and on that day there were injuries on your person, yes, it could have been a plea about the scuffle.
No.
I have not found anything. You absconded from the place of occurrence.
Mine.
For 10 days, police managed to arrest you from someplace else. You were hiding somewhere, right? Then after search it again, you made the vanishing act
Mine.
for 4 years to become a priest at Kamaikha.
Right.
So your all these acts,
Mahakamakhya could not save him.
Kamaikha is not to your rescue. Could not.
Give me 2 days.
I have handed over the
Mine.
copy.
I have received.
Tomorrow at
Mine.
10:30 will do.
Mine. Problem.
Yes, we have seen. It
Mine.
is a case of direct evidence.
Mine.
Mr. Anjedas, learned amicus curiae, has expressing difficulty, personal difficulty on his part today, has paid for listing of the appeal tomorrow. As the prayer is not opposed by Mr. K. Das, learned additional public prosecutor who is in attendance, come and list the appeal tomorrow for hearing. What I do?
Obliged. I'm obliged.
As pattern.
Obliged.
For pardoning.
Item 16.
You have already received a paper book.
Paragraph 11, Lordship, that the interim relief, prayer for interim relief will be considered today, Lordship. My prayer was that the amount was sought to be recovered without issuing any notice, Lordship. So that I am pressing today, Lordship. My friend may obtain instructions, but that recovery is going on and at the rate of
Take 1 minute. Yes, MS Sharma. What about the interim prayer?
Lordship, if Lordship grants me a last chance, 7 days' time, I'll obtain instructions.
Okay, then on the interim prayer. I don't expect that you'll be able to file a counter affidavit, but on the interim prayer. Come out with reason if I don't think prima facie
Yes,
any reason to deduct
yes.
or reduce the pay from the pay advertised. Heard Mr. MP Sharma, Learned Counsel for the petition, and MS S. Sharma, Learned Standing Counsel, Guwahati High Court, for the response number 3, 4, and 6. MS Sharma has submitted that she has not yet received the necessary instructions to file a counter affidavit also as regards the interim prayer post up. Insofar as the prayer for interim relief is concerned, MS Sharma has sought for further 10 days time post up. The prayer made by Ms. Sharma is accepted. Release the case on. Slide over a bit.
68.
Keep your flight.
Bail hearing attend was no?
CD receipt, Lordship.
Earlier Lordship has granted on bail, Lordship.
Hmm?
Earlier, one of the accused person has been granted bail by your Lordship.
Now, on parity, what is a case of parity?
No, Lord, I'm not insisting that.
Ah,
That's
not on parity.
No, I'm not on that. I'm not on that.
Because that other bail order was
Page 20.
that petitioner was suspected to be involved,
Lordship.
right?
Yes.
Sufficient incriminating materials are not available against the petitioner during the course of the investigation. But such is not the case here. What is your explanation about this seizure? You have yourself annexed the seizure list.
Lordship, I have annexed it.
Huh?
Lordship, actually,
What is your explanation?
my explanation is that, Lordship,
What is your statement here?
no, I'm not written in the bail petition, Lordship, but actually, Lordship, I
Yep.
purchased those Lordship articles. I purchased those, and unknown to the fact that those are stolen articles, Lordship.
How the materials have found the way from
shop.
Gorsuk to Roha?
Roha.
Gorsuk to
Roha,
Roha. This is a matter of investigation.
Lordship.
It is up to them whether they want to take you in custody or not, but that is a different matter. We cannot say that he should be taken into custody.
Lordship.
But so far as whether case of pre-arrest bail is concerned, is made out or not, it does not make out. Because of your this recovery of these items in your house,
Lordship.
it will be worth something. What are the other materials?
Lordship, sufficient materials against him, Lordship, and 42 battery and chargers are recovered from his possession, and 445 battery and 157 charger yet to recover, Lordship. So his custodial intervention is necessary, and statement of seizure witness and other co-accused, Lordship, all implicated in Lordship.
Hmm.
And then-
Hard. Mr. Sharma, this petitioner is found to be involved. Privacy.
Involved, Lordship, I purchased those articles. Lordship.
Purchase. Where is your material of purchase?
Not the accused person.
Receiving stolen property is as good an offense
I'm
as
not aware, Lordship, that those are stolen articles. Some people.
how can
person
it
come
be?
And I purchase it.
You these are batteries of companies
Company.
product.
Lordship.
You purchase against receipt. You cannot purchase without receipt. These are not
They
these are not rice bags
Lordship.
you purchase from a farmer who is unable to give you a receipt.
Lordship. But
These
they
are
receive-
products, branded products of
Products.
companies.
Companies, Lordship.
If you receive such used material,
Lordship.
you have to receive it through receipt.
Receipt, Lordship.
Oh, where is
But
that?
those receipts are not, they refuse. to
Along
give me
with
receipt,
payment of GST and all.
Lordship. They refuse to give me the receipt,
Oh,
Lordship.
then
They
you
refuse.
should not have received it. Purchased
Lordship,
it.
because
This
it is,
purchase, this
in the
plea is too
it is not
weak.
Not so high price, Lordship. That is why I have purchased it, Lordship.
Person
Not so
who
high price.
purchased a stolen property, Lordship, he is equally liable, Lordship.
Yes.
Lordship, give me
We
support
don't
for
know
it.
whether they will take you into custody, but this is not a case of pre-arrest bail.
I
You
will
are
cooperate,
found involved.
Lordship. I will cooperate with the investigation agency, Lordship. In fact, those things are already recovered, Lordship. So I will
Taking
cooperate with the investigation agency.
interrogation of a person within custody and outside custody is two different things.
Lordship, I will
Our
appear,
Mr.
Lordship.
A. Sharma, learned counsel for the petitioner, and Mr. M.S. N. Das, learned additional public prosecutor for the respondent state. By this application, लिखा है सागौर. The first information report was lodged on behalf of Messrs. Ronak, R-O-N-A-K, Enterprise. As per the FIR lodged on 13/3/2024, Messrs. Ronak Enterprise has a Godam which is located at Poob, Boragaon, Gorchuk, Guwahati. Full stop. An incident of theft took place on 13/3/2024 in the said Godam. Full stop. On being checked, number of 1 is e-rickshaw battery, page 11. 2 e-rickshaw chargers and e-rickshaw parts were found stolen from the Godam. Full stop. When at around 7 p.m. on 13/3/2024, staff of Messrs. Ronak Enterprise staff of Messrs. Ronak Enterprise discovered that the Godam had been forcibly entered by breaking its lock. Full stop. The CCTV installed at the premises, Godam premises, was found in broken condition, and the DVR box was found stolen. Full stop. Para. Mr. Sharma, learned counsel for the petitioner, has submitted that the petitioner is a businessman who runs a hardware shop at village Bokotgaon, Kamma Police Station, Roha, and he has obtained a license from the jurisdictional Monipur Tup, page 16, Gaon Panchayat, to run his business. He has submitted that the few of the petitioner had purchased few of the items which were later on found allegedly stolen from the Godam mentioned in the affair. Full stop. Mr. Sharma has further submitted that a co-accused Amran Alam, Amran Alam, who was suspected to be involved in the theft case, has already been extended the benefit of pre-arrest bail by an order dated 31/5/2024, passed in AB 1406/2024. MS Das, learned additional public prosecutor, who has received the case diary, has submitted on the basis of the materials collected during the course of investigation carried out so far, available in the case diary, that the petitioner is found to be involved in the crime, in the act of theft, as a number of stolen articles, stolen from the godown of Messrs. Ronak Enterprise were recovered from the house of the petitioner. I have considered the submissions of the learned counsel for the parties, and also have also perused the materials on record, including the materials available in the case diary. Full stop. Where it is evident from the search and seizure list, MR number 67/2024, that it has emerged that on search of the house of the petitioner on 23/2024, a number of articles, namely page 613, 1, 2, 3, 4, 5, 6, were recovered in presence of witnesses, and those articles, those seized articles, were identified by the representative of Messrs. Ronak, representative of Messrs. Ronak Enterprise, as the ones which were stolen from the godown of the at Boragaon, Gorsuk, Guwahati on 13/3/2020. Full stop. Para. The submission of Mr. Sharma, learned counsel for the petitioner, that the case of the petitioner should be considered vis-a-vis the benefit extended to and co-accused, Amran Alam on Piriti, upon consideration, is not found acceptable on the ground that the co-accused, Imran Alam, was extended the benefit of 3 years bail as no incriminating articles were or are found to be in custody and possession of the said co-accused. Post on the other hand, comma, a number of article or material that I've seen before, number of articles, comma, stolen from the Godam of Messrs. Ronak Enterprise have been recovered from the house of the accused petition, present petition. So as such, comma, the case of the petitioner is not found similarly circumstance as like the co-accused, comma, Cameron Alam. Full stop. And as such, comma, the contention that the petitioner is also can also be extended the benefit of pre-arrest bail under section 438 CRPC on the on purity is not found maintainable. Full stop. Para. As a number of stolen articles have been recovered from the custodian possession of the petitioner, comma, this court is found that the case in hand is not one where the privilege of pre-arrest bail under section 438 CRPC can be extended to the petitioner, as the petitioner is found privacy involved in the act of theft in the Godam of Messrs. Ronak Enterprise on 13/3/2024. Accordingly, comma, this application being found devoid of any merits, comma, stands rejected. No way you are found explicit